patiently to introduce this band of misfits. They have approximately a century worth of years in the legal field, give or take a year or two. So without further ado, I will hand this recording, this video, this soon to be large amount of information to the illustrious Kathryn Korn, to Eagle Eye Terence Murphy, and to the jack of all trades but common at none, Craig Judson. So without further ado, please educate us all.
Thank you, Doug. I think. Let me share my screen. Can you guys see the screen? Are we good? Okay.
We can see it.
Perfect. So I'm very honored to be presenting tonight with Kathryn and Terry. And I've known them a long time. We've had cases against each other. We've collaborated on cases, and they're really been a pleasure working with them. So we've been asked to cover several topics this evening. Issues regarding guardians ad litem, court-appointed counsel, conservatorships, powers of attorney, private fiduciaries, role of legal counsel, and we added in a few additional topics in our discussion this evening. We also spent a lot of time trying to come up with the most horrific scenario that we could think of. The sad thing is this type of scenario that we'll present in a moment actually exists out there, and we see it far too often. So we have a couple who've been married a long time, second marriage, and they each have kids from each of their previous marriages, and dad takes ill. He's severely ill, and the other spouse has declining capacity. We've all seen this type of situation. So what happens? The vultures start circling. That's Mr. Hausman on the left. And then they plan their attack. And this is when the attorneys go to work. So for the next several slides, I'm going to lay out the sort of the facts of our case. So mom and dad have been married for 18 years. As I said, it's their second marriage. They're up in years. Dad has 2 kids from the first marriage. Mom has 3. And generally they're close. This has been a good blended family, and they've spent holidays and other family occasions together. But they rarely socialize outside of their parents, and mom's kids do not live close. Dad was admitted, well, he's now in a subacute facility, rehabbing from a broken hip, and he just tested positive for COVID. He has serious signs of dementia, and he really doesn't understand why he's in the hospital. And this is a very common symptom that the doctors are now starting to see in the elderly. When they get COVID, it may not be a situation of the respiratory distress that we know has been so serious around the world, but a number of seniors are developing dementia-like symptoms and really becoming disassociated with reality. Now, mom has had better days, and she's now really afraid her husband's going to die. And she expresses these feelings to, the family. She's home alone, isolated. And of course, since her husband's in a facility, she cannot go and visit him. And as time goes on, she's showing more and more confusion and memory issues. She doesn't really know what to do with the bills because that's always been her husband's role. Now, they had an attorney for many years. His name's Larry Lawyer. He's an estate planner, but all he does is estate planning. He really does not handle probate and trust administration cases, conservatorships, certainly not. He's not a litigator. When they first started going to Larry, they did sign a community property waiver of the conflict of interest. They do have a joint trust with 3 schedules. The schedule of assets are dad's separate property, mom's separate property, and of course, their own community property. They have a home, a second home, that both are encumbered. Dad has a pension, but they have very little liquid assets. Their assets, Larry determined, are all in the trust. They have powers of attorney naming each other, but no successors. And the Advanced Healthcare Directive, or power of attorney for healthcare, is just a simple California Medical Association form. And those of you who are familiar with that form, it grants authority to make decisions, but it doesn't provide any guidance for healthcare decisions or end-of-life decision making. So dad's kids are very concerned that mom's failing, and she can't find their estate plan documents. The kids are worried that she really can't make coherent decisions regarding herself or her husband. They're very worried about the dad's cost of care and what's going to happen to their inheritance. And so the kids called Larry Lawyer, made an appointment to go see him, and they brought their stepmother with them. And from the hospital, they did get a copy of the Advanced Healthcare Directive, and that's how they found Larry. So now, go ahead.
So at this point, the dad's kids again show up at the office of Larry Lawyer. And while they're there, mom is perfectly clear that she's in great shape. She can handle all the decisions for dad, health-wise and financially. However, dad's kids are sitting there realizing the reason they're there in the first place is because they feel that she does not have sufficient capacity at this point. They distrust her kids, even though socially they've gotten along well in the past. And so prior to meeting at Larry's office, the kids went to the house, went through it, ransacked it, looking for estate planning documents, could not find them. So they suspect that mom's kids have copies of all the documents and have that estate planning binder. So dad's kids have come to the office with the idea that Larry should file a conservatorship petition naming them, dad's children, as dad's co-conservators. They also think that their stepmom should be conserved. And because the kids don't live, her children do not live close to mom and dad, dad's children would prefer to be appointed as her co-conservators as well. So initially, and while we're still at the office, what advice could Larry Lawyer give to dad's kids?
Well, I have a question. Who should Larry Lawyer meet with? We've all had the scenario where the kids show up at the office with mom, who insists that she's capable, competent, oriented, and can handle things. Should Larry Lawyer meet with the kids at all? Or should Larry Lawyer say, okay, nice to meet you, sit down in the waiting room, and I'm going to talk to mom first?
Absolutely, Terry. I think you're right. That is a consideration that we all have to deal with. But so often our elderly clients feel comfortable with the kids. They invite the kids in, when we go to meet. But that is a problem because I think in this case there's a real conflict of interest. Larry's client is his client. Mom is his client. Dad is his client. Kids want a conservatorship. And if he files a conservatorship proceeding, he could be taking a position that is contrary to the interests of his existing clients.
So what do you do in the case where mom comes sailing in? She's somewhat intimidated by, having dad's kids sitting there and talking for her. And she says, oh, no, it's just fine. I want them here. I waive any conflict that may exist. How do you handle that?
I mean, if they come into my office, I try to assess, are they there to pursue their own agenda or mom's agenda? For example, under, was it Evidence Code 952, I think it is, if they're there to assist in furtherance of the purpose for the representation, then it's privileged. But if they're not, if they're pursuing their own agenda, which is, we want you to conserve mom, and mom says, no, I'm fine, there's an obvious conflict. I mean, I don't think they should even be in there. And when it happens that they end up in there and then you figure out what's going on, at that point, sometimes you have to basically tell the clients, I can't do any work for any of you. I mean, they're not your clients at that point, particularly the kids. Mom is. The waiver that mom and dad signed doesn't run to them. It was only as between the two of them. So I think Larry needs to particularly send the kids on and, just pursue independent counsel and get advice from somebody who doesn't have an existing relationship with mom or dad. That's my feeling.
Well, I think you're right, but it even goes further. Larry really doesn't have a court practice. And so to get involved in a conservatorship with no experience, I think he's exposing himself to potential problems. As we all know, conservatorships are complicated, they're detailed, they're a royal pain to put together a thorough conservatorship petition. And I think he really needs to bow out completely at this point, because his conflicts and practicing out of his normal area and comfort zone, I think is a recipe for disaster if things don't go well. And given this scenario, any attorney ought to immediately think about what can go wrong, because there's an awful lot that can really go wrong in this case.
And that brings up the final question. Can Larry, if he were able to, let's pretend that Larry does have a practice where he does do conservatorships, can he prepare a petition to conserve his client?
Well, so mom thinks she has capacity, but the kids come in saying, mom, certainly dad we know does not have the capacity, but if the kids are saying mom doesn't have capacity, how can Larry get a waiver from mom for this particular action? I think that's a real problem.
I mean, it's my position. He can't prepare documents to have either mom or dad conserve. There's ethical issues regarding commencement of a conservatorship proceeding to conserve your own client. I mean, dad may need one, clearly, but I don't think Larry's the person that can file it. He can't file a petition to request that his own client be conserved. As far as mom, if it's unclear whether or not she has capacity, she may not need one, she may need one, but it's the same story for Larry. He can't file a petition. He basically has got to tell them they have to go seek independent counsel. He can't take a position adverse to his client, particularly mom, who says, I'm fine.
Right.
Yeah.
I would agree and concur. I think that Larry, initially, when the kids come in, were it me, I would not have that initial meeting with the kids in the room. I, from the beginning, would explain to them I can't meet with them. And that might cut down a lot of heartache, as we've just talked about, between mom and the kids.
So as attorneys, and we should educate our staff as well, when they know that family members are calling in to make an appointment on behalf of an elderly mom or dad, sometimes that's just a red flag, if not a yellow flag for sure, as to what's going on. I think it's good to know those type of things going into a meeting, who's actually initiating these conferences.
Right, and in this case as well, Larry was the estate planner. He's aware this is a blended couple, blended family. I would be curious why just dad's kids are there. Did they offer to say, well, we have mom's kids standing by to hear whatever we talk about? Regardless, I just think that Larry has to let them know he represents mom and dad solely, and probably send the kids to the waiting room or out to their car.
So Terry?
Well,
go ahead.
as far as the conservatorship proceedings are concerned, one thing that I want to emphasize, and I've had this discussion with a number of people, including some of the judges who hear this matters, is kind of what's the root word when you look at conservatorship? It's conserve. It's not spend. And we're going to get into this later, because there seems to be a lot of expense incurred in conservatorship proceedings, some of which I think is unnecessary. But the whole idea of the conservatorship proceeding is to protect and preserve the assets of mom and dad, in this case, to the extent that you can. So, I mean, that's where I normally start when it comes to a conservatorship proceeding. As far as Larry representing mom, as I mentioned in the last one, Larry can't file a petition requesting, well, I take that back. If mom had the capacity to be the petitioner to request that she be conserved, and if mom was the one that was requesting that, say, a professional fiduciary or one of the kids or somebody be appointed, I think Larry could under those circumstances. But if mom takes the position that she doesn't need to be conserved, then he can't file a petition asking for a conservatorship proceeding to be imposed on her. Now, maybe what this question asks is, mom wants Larry to represent her in connection with petitions that dad's kids may file requesting that she be conserved or that dad be conserved. I think Larry could, but the question is, should he? If Larry doesn't have experience in the conservatorship arena, he can create a real twisted road for everybody if he jumps in and purports to represent mom, either in objecting to a conservatorship proceeding or getting involved in the proceeding for dad. There still are the conflict questions, but what role should Larry play? Another question is, does mom even have the capacity to hire counsel at that point? For example, if she has diminished capacity, we don't yet know how diminished it is, she may no longer have contractual capacity. If that's the case, she doesn't have the capacity to engage counsel. I mean, there was that Sullivan case that's referenced a lot in these proceedings, in which counsel comes in with the proposed conservatee on the date of the hearing, and the court determines that that individual doesn't have, or that the proposed conservatee doesn't have the capacity to retain counsel, and then court will appoint counsel. As far as dad now being on the ventilator, that was inserted because what we're headed towards, which is the following point, Craig has created Department 1530, which is good. Dad's now
judges, no judge shopping.
Dad's now on a ventilator, which in and of itself can create some exigent circumstances that can warrant the parties going in ex parte. So as the next question or next comment states, everyone shows up. I mean, we've got mom, we don't have dad. We've got some or all of dad's kids. We've got some or all of mom's kids who are from out of town. And it says the pleadings indicate the existence of a trust.
What does that say to you?
Pardon?
What does that say to you with conservatorship proceedings? And if you were sitting pro tem and you find out there's a trust, how does that complicate it?
Well, it complicates it because of the fact that the court has no jurisdiction over the assets that are held in a typical revocable trust or any other trust for that matter. Assets in a trust are subject to different jurisdictional requirements. And so a conservator cannot reach into the trust and take control over trust assets. There has to be a whole separate proceeding filed. Now, sometimes people will appear in Department 1530 and only have a conservatorship proceeding pending. They'll have probably at that point have competing petitions for appointment of conservator, person in estate, ex parte petitions for appointment of temporary conservator, person in estate. Sometimes people will have done their homework and they will, for example, have done a record search regarding deeds, find out how the property is titled. They'll do other, if they can't find the estate planning binder, they'll dig a little deeper and they'll find that virtually all the assets, as the scenario indicated earlier, in the trust. So they'll file a trust proceeding, and they will, in that trust proceeding, allege either that, well, they'll allege that dad, who has dementia, no longer is capable of serving, so he's disqualified, that mom doesn't have sufficient capacity to handle the financial matters because she never has, and she has diminished capacity. So they would question her ability, and they would be in asking that the court appoint a temporary trustee to take control over the assets of the trust to make sure they're properly administered.
So Kathryn, should the court appoint anyone at this stage?
I think at this point, the court has some real considerations. And just to step back for one moment, recall that mom and dad's estate planning documents apparently only provided that in the event of an inability or lack of capacity to act, they only named each other. So if the court is looking at competing petitions, none of these people, none of the kids have appeared in any estate planning document. So there's no way for the court to see what were the settlers' intent? What did each of these individuals want in the event that they're named, conservator or power of attorney was also unable to act? So the court is probably going to be looking at competing petitions, we would assume, probably for both temporary and general conservatorships, because if you bring a petition for a temporary conservatorship, you must also bring one for a permanent or general conservatorship at the same time. Likely, not sure that everybody did do their homework, so it is highly likely that those petitions are for both the person and also the estate. And then on top of that, the court is probably looking at dad's exigent need for somebody to speak. If in fact mom is not completely appearing to the court as if she's up to, a normal capacity range, the court, in an abundance of caution, might want to appoint somebody. But let's assume there are 3 kids on each side, who to pick. And then I think at this point, the court may look, if nobody asked to have, a family member appointed, the court may look to appoint a private professional fiduciary to step in. So I think there are many issues and alternatives that the court's has to consider at this point. And again, going back to a conservatorship takes away a person's rights. And while a court needs to protect, as Terry pointed out, a person, I think it's also very important to understand that it should be as least restrictive as it possibly can. So moving on to our next slide.
Well, let me answer you both. Mom and dad don't have liquid assets. So to me, that says, what are their sources of income? And if dad's in a nursing facility, there's going to be some significant bills. And then mom still has her regular expenses of the house, Social Security. And then from the facts that we know at this point, dad has a pension. So assets being held by the trust, but what about the pension? Can the trustee reach the pension funds if they need to pull money out?
Well, it would depend to some extent whether or not the couple had their checking account into which their automatic pensions or Social Security are deposited, or in their names as trustees of their trust. If they're not, they're outside the trust.
So
And
Right. Many people don't. And also, I found that usually there's a reason to have a conservator of the estate, even if you have a trust, because not only do you have, for example, pension related issues, which account is it going to, but maybe you have to deal with Social Security. Maybe you have to deal with an IRA administrator. A lot of folks have large IRAs and decisions may need to be made. For example, mom and dad may not have been taking RMDs. So who has the authority to make those decisions? It's typically not a trust asset. Also, filing tax returns. How did dad break his hip? He fell going into a building. Maybe he's got a personal injury claim to be pursued, and that would typically be pursued by the conservator on his behalf, not by the trustee. So make sure you take a look at that, those circumstances.
I think that's a very important point. And sometimes I've heard attorneys say to clients, oh, you don't need to, or you don't want to start a conservatorship of the estate because you have to do accountings. And in this instance, excellent point, Terry, it's probably best to also have that conservatorship proceeding pending for an estate. Recall that if the estate is under $20,000, you can petition the court to waive the requirement of an accounting. So you're going to be able to save a lot of money in that instance and still have the protection over the estate, and also have someone, as Terry pointed out, to speak to various entities on the estate's behalf.
But let's go back a step. Everyone comes into the courtroom. Judge in Department 1530 says, okay, you can't make all this arguing, this ruckus out in the hallway. I want everybody to come in, and to sort of borrow a line from Judge Sugiyama. What's the end game? What's this about? You know, we have now 5 kids, mom, dad on a ventilator. We could have 3, 4, 5 different attorneys showing up because everybody has their self-interest in mind. And where's this go? Because all this discussion we're talking about is this case started really simple, and now we have conservatorship of the person estate for dad, maybe conservatorship person estate for mom. We have a trust proceeding. We have lots of filing fees. We have attorney's fees being run up several $1,000s an hour combined by all of them. And why? I mean, it's just, what's the purpose behind all this action? Because we're talking about all these procedural things, and as attorneys, we're always looking at, you know, what's the right strategy and all that. But too often, I think we don't step back and say, wait, where are we going with this? What should be the end result? And that doesn't come up until way down the road. You get into mediation, and by that point, the case is just about attorneys seeking their fees.
I think that part of the problem is that not one of the attorneys representing the 2 factions of children thought to call up the other attorney prior to showing up at court. Often the very first thing you should do is pick up the phone, call opposing counsel, and talk to them about the case. Because as you point out, Craig, there's probably 3 attorneys sitting there at somewhere between $425 and $500 an hour and fighting, and then maybe a private professional comes in with yet another attorney, and you're going to go to mediation, and perhaps you could have started that ball rolling before you even had the ruckus in the hallway.
Yeah. So
why would someone request that a private fiduciary be appointed?
Neutrality. Rather than let the kids fight back and forth and run up huge expenses and nothing ever gets done, sometimes it's easier just for the court to select a private professional fiduciaries, or have the parties see if they can agree on someone, and just bring a neutral party in, doesn't have the emotions, doesn't have the animus that all of a sudden starts to come out in these type of cases.
But aren't the kids going to say that just creates another unnecessary layer of expense, because you're going to have to pay the fiduciary, you're going to have to pay the attorney for the fiduciary. You know, we're going to keep battling, because the fiduciary at this point is only coming in as a temporary, whether it be trustee or conservator. We're going to keep battling. So instead of having 5 sets of lawyers, you have 6 sets of lawyers.
Yeah.
But using a temporary, at least using a private professional fiduciary as a temporary could be a cooling off period. It would provide a time period whereby the neutral comes in, discovers that, oh my gosh, there really aren't, forget the liquid assets, there's just not a lot of assets. There could be mortgages on the homes. I mean, to kind of have a neutral sit everybody down and say, this is what the assets are, these are the expenses. And that is a sobering thought when the kids are looking at their inheritance being used for substantial medical bills. My personal opinion would be to even have them for the temporary period might make a lot of sense in the long run.
So we have a question right off the bat, though, is, okay, Dad we know is incapacitated. He's on the ventilator. But do we really know Mom's incapacitated? Many times we do not have a capacity a cap deck filed with the court at the time of the ex parte. And so we've raised the question about maybe suggesting to the court, or the court on its own raising the issue of an evidence code section 730 evaluation for Mom, which would be the court selects an expert to evaluate Mom, not where each side goes out and hires their own, but we get some testing. For example, Dr. Freitag, who was our speaker last week, and maybe he should do some testing on Mom, and let's see, really, does she have capacity or not have capacity? I think that's a threshold issue as to at least half the case, right off the bat, instead of getting months and months down the road and we find, no, Mom has perfect capacity. Or maybe not perfect, but she can get along. So,
or what does Mom have capacity to do? Does she have capacity to handle financial affairs? Does she have capacity to make her own medical decisions? If Dad passes away, does she have the capacity to marry? We've run into that a number of times. What is the extent of her capacity? Can she go buy a Corvette for her new boyfriend when Dad passes away? Can she make gifts to the kids? Does she have capacity to do that? Does she fully understand what her financial needs are going to be down the road? All those things can be looked at by a good expert.
And I think the time to bring up all of those issues is when that appointment is being made. I think that as counsel, you need to say, what is the point of this capacity evaluation, and outline, so that when it gets to Dr. Freitag or whomever, he has these questions that he knows he needs to opine on.
absolutely. Meanwhile, as soon as you file, it should be accompanied by a petition for appointment of counsel for Mom and Dad. So then we get the CAC, the court-appointed counsel, who now steps in, at least ostensibly being paid $110, $117 an hour through the county criminal conflicts program. But so now we have another attorney, and whether or not Mom and Dad actually walk in, or Mom walks in with Larry Lawyer or some other attorney to represent her, court most likely will appoint counsel on her behalf. But what about Dad? Dad can't speak up. So we have a note here about a GAL, a guardian ad litem.
Well, one thing about a guardian ad litem, a few things. Because we have this trust, I think it's probably code 15405 does permit the court to go ahead and appoint a GAL, a guardian ad litem, for, I think the quote is, a beneficiary who lacks capacity in trust proceedings. And that can be a lifesaver because avoids the necessity of appointing conservator right away. So maybe right then and there, at the very least, we could get a GAL for Dad as far as protecting his interests as they pertain to their joint trust.
But what about if the recommendation, or at least on the court's own decision, a private professional fiduciary is appointed? Private professional fiduciaries aren't just conservators.
They can also be, yes, a guardian ad litem does not, it may, but it's not required that it has to be an attorney. So a GAL could be appointed as well.
What about the fiduciary being appointed as a temporary trustee?
Well, is there a trust proceeding in front of the court?
Not as of the scenario that we wrote.
Right.
But oftentimes, no, the trust proceedings do not get filed up front.
Right. So a guardian ad litem could be appointed to protect Dad's interest for the trust by the court. but, you know, again, it's specific for a specific purpose for, as regards to the trust itself.
So
I mean,
one,
I've been appointed GAL in a trust proceeding that is yet to be filed, but
Correct.
usually it doesn't happen that often. Typically, it's filed once a proceeding is commenced. I mean, we got a little ahead of ourselves, I think, on court-appointed counsel. One thing that we noted in the scenario was that basically dad has dementia. And assuming that in the conservatorship proceeding, someone's going to be asking for dementia powers, the court's required to appoint counsel for dad in that scenario. So that's going to be more automatic than mom. The question with mom is she's going to be in objecting. Basically, there's a less restrictive alternative. You know, I've got capacity. I can handle my own affairs. And on what basis does the court feel that they need to appoint counsel for mom? Aren't they going to need some facts to show that either mom isn't properly handling the financial affairs, is neglecting dad's care, or is neglecting her own care?
And with regard to court-appointed counsel, if the allegation in the petition is, as you pointed out, that there is dementia, yes, court-appointed counsel is required, but oftentimes attorneys will get their petition in and they forget at that time that they're filing the initial petition to have an attorney appointed for the proposed conservatee. So you don't have to wait until you get to the first hearing and the court goes, oh, dementia, now we need to appoint counsel. And you've wasted maybe 4 or 6 weeks. So if you're making that, if you're filing your petition and you know that the proposed conservatee has been diagnosed with dementia, you should absolutely at that time request that the court appoint counsel.
Right. I think if you put it in your ex parte application for the temporary and in the proposed order appointing temporary, then it automatically goes in and you can turn the wheels a lot quicker. And again, you don't have to waste a hearing while you wait to get counsel appointed.
so let's say Doug Hausman is appointed as court-appointed counsel for dad. And dad, I'm trying to keep you awake, Doug. Dad's on a ventilator. How does Doug represent a client who he can't communicate with? Okay. I mean, those of us who are on that panel, we do get appointed on cases of clients with advanced dementia or in a coma. I've had several of those in the past year. The ventilator situation, unfortunately, you know, it's out there with COVID. How do we know what our client wants?
Well, the role of some courts I know do encourage court-appointed attorneys to form an opinion about what would be in their client's best interests. But I have found personally that varies in jurisdictions. You know, Southern California is very different than Contra Costa, Los Angeles County, for example, than Contra Costa County. While the primary duty is to represent the client's interests, I think you have to look at your ethical standards as well as the applicable laws, while I think secondarily, you do have a duty to try to assist the court in resolving the matter that's before the court and needs to be decided. I just a little bit, it's not this scenario, but I have been appointed on many occasions where, for example, Larry Lawyer was the client's attorney. And it's sometimes you're being put in a position where you're advocating what you believe is in your client's best interests, and that's not aligning with the private attorney that purports to represent the proposed conservatee. Just wanted to remind.
I mean, a lot of the court-appointed counsel cases, it's fairly straightforward that client doesn't have any capacity, and our job is to make sure that our client's civil rights are protected, that least restrictive alternatives are considered and brought to the attention of the court, and add in a sort of third-party view on accountings and make sure that money is being preserved properly and spent properly for our clients. But you get a situation like this, there's no guidance out there really as to how far we can go and how much authority we really have as court-appointed counsel. But the one thing is, the judges everywhere look for guidance from court-appointed counsel. And even though it's basically a volunteer position, it becomes a really, really important role in these type of cases. I tend to view it more as maybe we're the neutral, not quite a mediator, but the best thing in our client's interest is to find a way to bring these proceedings to some type of conclusion before mom and dad go bankrupt by everybody continuing to fight and more court hearings. So,
Going back for a second to the question that you posed regarding Mr. Hausman's representation of a client he cannot communicate with, the extreme situation, at least in my mind, and the cases I almost hate to end up with, are the ones in which you have an individual who's on life support, non-communicative, no prior written expression of intent, and then the question of whether they're maintained on artificial life support or if that's terminated. It's the Wendland case. It's all those cases dealing with termination of artificial life support. And then typically you've got a client that you can't communicate with. So in those instances, you really need to drill down and see what you can find indirectly regarding what your client's wishes might be. Is there any past history, any past record, medical records? But ultimately in that situation, I always find that in advocating for the benefit of the client, the conservatee who's on life support, how do you advocate to terminate life support? That gives him no chance, or him or her no chance to come out of it. I was in one not long ago where there was a request to terminate, and the petitioner was unsuccessful, and the individual improved, and he was returned from ICU to skilled nursing facility where he had been in residence. So those are tough ones. Like I said, I always hate to see those come, but sometimes you have to drill down on other sources if you can't directly get information from your client, and then try to at least determine as best you can what they would want under those circumstances.
Just recently, my associate Kyla Hale was appointed as court-appointed counsel. Her client had been in a coma and on life support for over 7 years. The medical records and recommendation of the doctors were very clear that her client is basically gone and has been gone for many years. And the body has just been alive because of the intervention of machines. And all of a sudden there's a competition between the client's daughter and the client's sister. And the aunt's a little wacky. And it was a really, as you said, Terry, it was a really frustrating type of situation, a very gut-wrenching type of situation to be caught in the middle as court-appointed counsel. So that situation should never arise. I would think Larry Lawyer, and that's why I put it in the scenario, was really wrong to just use a fill-in-the-blank form and give powers. You know, I teach at the law school at UC Davis, and in my trust and estates class, I teach the students their assignment this week, to specifically deal with the client on what their desires are and write those out. And I think the estate planners can do the litigators a huge favor by trying to be as specific as possible, so we have direction from the clients, and where the clients have really considered it while they're healthy, and we have something to look at instead of trying to interview various family members or friends. And those are just gut-wrenching type of cases.
And just to follow up on that, because we also do estate planning, it's essential, and I always advise my clients that it's great they filled out their wishes, but they need to, I ask them, have you talked with the people that you have appointed as your agents? Have you shared your thoughts? And I mean, really talk to them, because I'm sure we can all agree. How many times I get phone calls or whatever from, people at the hospital saying, my God, I didn't even know I was on the advanced healthcare directive. Do you have anything in your file saying what my dad wanted? I mean, like, no, I don't. I just know, you didn't talk about this. It's not that easy. And you're right. You might have to drill down through family members if you're a court-appointed counsel to find out what you think they want. And another one last alternative, I have turned to the court for directions to find out what exactly my role is, if it's in doubt. So just wanted that's another alternative as court-appointed counsel.
So one of the tests before the court can actually grant a conservatorship is to explore least restrictive alternatives. We've talked a little bit about, the trust, and maybe the trust is the proper vehicle for management of their assets. But if the powers of attorney, is there something maybe could be done for mom that she could direct at least her power of attorney and name one of her kids, if that's what she chooses, to serve as attorney in fact for her? I would think that's a question that should be taken to Dr. Freitag as to whether she has a level of capacity to execute a power of attorney, which may be different than having capacity to, manage a large estate.
And that's important because mom may not have the capacity to execute a power of attorney or an advanced healthcare directive, or make other decisions that are needed. Sometimes if a conservator is appointed, a conservator will file a substituted judgment proceeding. Or even if with court approval, the court could authorize a temporary conservator to file a substituted judgment proceeding. For example, to request authority to execute documents such as an advanced healthcare directive or a POA, if those are going to work. Now, sometimes if the family is fighting, it's just going to shift the battleground over to the proposed estate planning documents. Another one that I've seen a few times have been requests by a conservator to execute a post order. Typically, those can only be executed after the individual has been diagnosed as having a terminal condition, but the conservator can come in and request that. But again, if you've got the family in turmoil, you've got people continuing to contend that mom has capacity to make her own decisions, there's been no judicial finding of lack of capacity yet, and you're still in that battleground, you're just going to create another forum for the fight. Now, I know one of the next things on the list is mediation, and I don't want to jump to that too quick, but some of these things, if the parties do get into mediation, which I find to be effective most of the time, it may not be immediate, it may take more than one session, but it can get a lot of these things we're talking about now resolved, and you're going to get them resolved a lot less expensively and a lot more quickly than you will waiting to get into a courtroom with half-day settings, probably starting, November now? Mm-hmm. If you had a proceeding that started today, if you're lucky. So.
Have you ever, at the ex parte stage, tried to encourage the parties to go into immediate mediation before the hearing on the general?
Yes.
Yes. I mean, I'm in one right now where we've only got temporaries and we're going to mediation, and actually it's overdue. I remember in one or two matters, I proposed a pre-filing mediation to try to get the people for a mediator before they start burning money.
Right.
I think that's an ethical thing to do when you see these type of horrible scenarios, with the potential to just eat up all the assets and totally destroy relationships within families. That as attorneys, I think we can do some good for the parties by trying to force some communication and see if there's some middle ground, even on a temporary basis, or even on a limited basis to start and take some baby steps to try to rein this case in, all going back to the issue of what's it all about? What's the end game? Where are we going to end up in these cases?
I mean, many times you may not really get beyond the temporary stage, because if you've got competing petitions, how are they going to resolve? At least one of the parties is going to demand an evidentiary hearing. So the court's not going to rule on the competing petitions and objections without a hearing, and there you're back in the trial setting.
Exactly. I just wanted to go back, if I could, one last thing on court-appointed counsel. What would happen if the court did order mom to a 7:30 evaluation? We all find out that mom does in fact have dementia of some degree. So the court now orders court-appointed counsel for mom. And court-appointed counsel goes and meets with mom, and mom is slipping quickly. And court-appointed counsel determines that mom probably would benefit from being conserved because dad, according to her estate planning documents, is unable to act. There's nobody else in place. But mom is saying, absolutely not. I want you to fight this conservatorship. What do you do as court-appointed counsel in that case?
I think we have the obligation to represent the interests of our client, and whether or not we have personal feelings as to whether or not our client really has the capacity to fully understand. I think it's our ethical obligation. If mom says, I want to fight this, then we notify the court that our client objects. We file an appropriate objection. I do see a lot of attorneys who will say, Your Honor, my client objects, but we'll submit it on the pleadings. And, that's sort of sometimes a slippery slope. But we do have an obligation to our client, whether we're hired directly or we're appointed. We do have that obligation to be a zealous advocate for our client.
But I think as court-appointed counsel, for example, and I'm assuming we're talking about mom, that she's objecting to the petition that was for appointment of conservator filed by dad's kids. There are a lot of negatives associated with conservatorship proceedings. I'm going to lose my independence. I'm not going to be able to spend money. I'm going to be put into a facility, all those bad things. So I think it's an opportunity also for court-appointed counsel to do a little educating, to inform mom that isn't necessarily all bad, and it could be an opportunity for you to pick someone that you can work with going forward, because you're probably going to need more assistance. And rather than somebody imposing someone or ending up with someone you don't like, maybe there's an alternative. Maybe it could be worked out where maybe she would meet with a private fiduciary, for example. Excuse me. And, I've had situations where, they don't want the kids handling anything, but they bond with a private fiduciary. And then somebody can amend their petition, get the fiduciary in there, and then mom can work with that individual and, again, avoid a whole lot of unnecessary expense.
It seems like it's sort of a sliding scale of what the client's capacity and desires are.
Yep.
Exactly.
What we
some are adamant, and then basically you try the case.
Right. Try to help our client the best we can, making the best out of a bad situation. But push comes to shove, if the whole family's sort of hell-bent on doing what they think is right, as opposed to what they think is in mom's best interest, then we have to be that advocate and represent our client's interests. And if it means going to trial, we go to trial.
Yeah. Now, many times the proposed conservatee won't want to go to court, won't want to be in court, won't want to be put on the stand to either testify as to why they feel they have the capacity or subject themselves to cross-examination by attorneys for the kids, for example. So sometimes they just will refuse to appear, which complicates things. And so then you're defending your client in absentia, in effect.
Yeah. Which is hard because, then what does your client want? So are you court-appointed counsel, or are you acting more in the role of like a guardian ad litem? And we start to get a blurring of those roles.
Where do you want to go next? Mediation?
We certainly can go back into mediation. So we agree, we would encourage mediation as early as possible, right?
So who picks the mediator? How do you get a mediator? What do you do?
No, you can go off the court's panel list,
Mhm.
and there's some very, very good attorneys in our county that are very experienced. Terry being one. There's a plug for you, Terry. You owe me lunch. But yeah, there are some very good ones. You know, of course, there's retired judges, there's ADR services, there's JAMS, there's a number of independent people that are also very good. But I guess it depends what the considerations are. But I would think in a case like this, you want a mediator who is experienced with these type of cases.
Right.
You know,
So
whether-
do you, as an attorney representing, say, dad's kids, I usually try to educate my clients as to the various mediators and their strengths, you know, and try to offer 3 to 5 names. And I actually encourage them, you know, if they're really not getting it, they can call the mediator and talk to that person, you know, prior to. But I think it's important to do it early on and to educate them as far as what a mediation is like. And of course, now with the COVID pandemic, you know, people often will say, oh, do I have to be in the same room with somebody? Or, you know, I don't want to, you know. So I think just getting their expectation to reality is very important very early on. The
Yeah.
client.
I found with COVID and, you know, using things like Zoom for mediations, actually is, for some cases, it's a safer setting. And I don't mean just because we have breakout rooms, you know, for each side, but they're not physically sitting around the same table, or we'll run into somebody who, you know, they just don't get along with, you know, walking into the mediator's office. So in that respect, the remote mediations can be beneficial.
Right, and I think it's really important to plan and prepare for the mediation. Maybe put together a settlement proposal, you know, a confidential settlement proposal that you might even float in advance of the mediation. Tell everybody where you are, tell the mediator where you are in these particular issues, because that can be fertile ground for discussion once you get into the mediation, whether it be restrictions, whether it be rights and powers, things like attorney's fees. That'll come up, or conservator fees. Are they reasonable and necessary? The amount charged, all those things can be addressed in mediation as well, versus objecting, or even accounting matters. For example, you go into mediation, maybe you've got first accountant report that's been filed, somebody objects. Unless it gets resolved, for example, through mediation, the court might appoint someone like me or somebody else to serve as an accounting referee. And then all of a sudden you're in that forum where you've got somebody other than the court under, you know, section CCP 638, for example, going through the accounting and objections, possibly having a hearing and submitting a report to the court. So all these things can be ironed out in mediation if you approach it well prepared. And I think that's really, really important, because I hate to see mediations with parties walk in and, you know, it's almost a waste of time because they're not ready to participate in good faith in mediation and try to resolve the issues. Some are more interested in keeping the clock running.
Mm-hmm.
Kathryn and I are involved in a trust case where Judge George actually asked Kathryn, representing the private professional fiduciary, to, in a sense, have an informal meet and confer with all counsel to identify the critical issues that are necessary to have a meaningful mediation. And flowing from that, we're on the hopefully final step of settling a very complicated, drawn out case without ever using a mediator, just because Kathryn took the role of helping the different sides identify what's most important. And so I hope we get that resolved, Kathryn.
Me too.
But that is something to remember. If you're in the role of sort of being in the middle as mom or dad's court-appointed counsel, that does give you some latitude to try to rein in the kids on the fringes, for the benefit of your client. And so, that works if you have, an experience, you've been practicing for quite a while and you have an idea on how to deal with it, but it puts you in a sort of a righteous position to try to get those discussions going early and hone in on the real issues.
The other
ahead.
important part of that, I think, and I, having done a few mediations and acting as a mediator, is if I can encourage the attorneys to narrow those issues and then focus their mediation briefs specifically on those issues, it's enormously helpful. In addition, as a mediator, the more information you can get from people, the more likely you will be in a position where you can, drill down and work with people during that mediation. So I ask you, Craig and Terry, do you like confidential mediation briefs, or do you share them with all the parties? Or is it just case by case?
Well, from my perspective, I always encourage people to share their briefs, because if it doesn't get resolved, they're going to be filing trial briefs, which are not going to be confidential. So the cat's out of the bag. So share the mediation briefs. Now, if somebody has this key piece of evidence that they don't want disclosed, and I've had that. I've had a separate mediation brief submitted with a request that the information not be disclosed, and I honor that, of course, and I don't share that information. But typically, I encourage people to share their mediation briefs as well as whatever they believe the key documents are, unless there's been big document productions and everybody's got everything already. It's worked a few times in which I've encouraged the parties to submit in advance or to share in advance a proposed settlement agreement.
Yeah.
And it may not have all the terms to be ironed out. It may have some blanks, but you can get in, you're going to want court approval. Yes. Is there going to be a global release? How's it going to be termed? So rather than at 8 o'clock at night or 10 o'clock at night, arguing over the small details, get a proposal out there and work with that. So that I've seen that work in some kind of involved cases where counsel have been willing to do that. It's been helpful.
So I agree with Terry. In 36 years of practice, I have never submitted a confidential mediation brief, because what good is it? If you're not communicating, you're not sharing your ideas, I don't have to accept what the other side's proposing. They don't have to accept what I'm proposing. But if we don't sort of start to lay our cards on the table, you're just asking to go to trial. And that defeats the whole purpose of mediation. But it doesn't mean I won't sort of hold back, an ace in the pocket if it's something I really don't want the other side to know about. And then you figure out I will work with the mediator as to whether we should sort of give some hints of something that they may not have considered. But that's all strategy. But
Right.
I think there has to be some sharing of thoughts.
When you go to mediations, do you go with more or less a template of a settlement agreement, or are you relying on the mediator for that?
I sometimes will go with a template and try to fill it out as we're going through, as we reach agreement. Because I tell my clients that we may not settle the whole case, but it's a first step. And if we can knock off a couple of, low-hanging fruit type issues, then that's a start. And so let's deal with the easy things, and the hard things, a good mediator will pick up on the momentum of the discussion and be able to carry it through. And so, as we all know, many cases resolve not in the first mediation session, but it's the after discussion or a second session or even a third session. But, if we're really trying to focus on what's in our client's best interest, trying to resolve these cases I think everyone deserves that opportunity before they go to the great expense of trial. And if we have to try the cases, absolutely, we try them. So we are getting, we have about 20 minutes left.
Oh,
Maybe we should move on so we can get some questions. Let me go on to the next slide. This is how we would have ruled on the case. We would have appointed a private professional fiduciary for Dad. We would grant the temporary conservatorship of the person for dad. Conservatorship of the state, we had some questions about that. We would request a capacity declaration from the treating physician before asking the court maybe to order a 7:30 evaluation for mom. The judge expressed to us that she is concerned about restricting mom's rights, and we completely agree with that, and I think that's important to recognize up front. Guardian ad litem maybe should be appointed, especially if there's a trust proceeding. Court-appointed counsel should be appointed for both mom and dad. And the reason we thought private professional fiduciary, at least on a temporary basis, was the right thing to do is to prevent dissipation of assets and create better transparency. If you have the kids fighting on each side and who gets control of mom's assets versus dad's assets versus community property, sometimes it's better just give it to a neutral. We would order immediate mediation and return to court in 30 days, in the least with a list of critical issues for the court to decide, not to say, here's the whole case, judge. We would want court-appointed counsel to report on issues, assets, least restrictive alternatives. And we also thought right up front, ask the court for a stay on discovery pending further orders. Let's not get into running up everybody's fees and doing, creating a lot of busy work for everybody up front. Let's just focus in on what are the critical issues for mom and dad right now.
Many times the court will also, if they've appointed a private fiduciary, a PPF, either as temporary conservator of the estate or as temporary trustee of the trust, or both, they'll also ask the PPF to basically report back to the court regarding assets, whether they've been able to take control over, what's the status of the asset. So the private fiduciary or the person appointed in the temporary capacity will often be given that task as well.
Yes. So we had a couple other considerations that are more sort of wrap up type issues that, given the limited financial resources, we felt the court needed to take active management of this case right up front. And our judges, if we suggest it as attorneys, I found the judges will pick up on that. And because sometimes, you just can't let things get put over and put over and put over, as Kathryn said earlier. It just never brings about some type of resolution. And here, the key in this type of case is to protect and preserve the assets. And finding a way to do that is not easy, but we have to have a focus on the end game. We've talked about the role of court-appointed counsel and mom's capacity issues. The infighting between the kids may not be anything that can ever be resolved, but if the kids realize early on that they're going to run up huge legal bills and they're not going to get a hold of mom and dad's money to pay for their own attorney's fees, sometimes that changes. So I know the judges do have a preference for family members to be in control, if that's possible. In this scenario, awfully hard, especially with community property issues. If you have dad's kids taking control of dad and mom's kids taking control of mom, what do you do with the community? So that presents an issue. And as both Terry and Kathryn mentioned, sometimes substituted judgment to create new estate planning documents ultimately would be a good thing for counsel to consider. Any other thoughts, guys?
Well, on the fee issue, it really kind of depends. Are we talking about the conservatorship proceeding or the trust proceeding? In the conservatorship proceeding, there's under 2640 and 2640.1, where if you're a petitioner or even if you're an unsuccessful petitioner, you can get an award of fees from the conservatorship estate, or if it's a revocable trust, usually from the trust. If you're purely an objector, typically it's going to be no. On the trust side, normally the trustee can dip into the coffers of the trust, and the court usually doesn't tie the hands of the trustee up front. They'll wait until after there's an accounting and find whether there's a basis for surcharge. But if you're objecting in a trust proceeding, typically you're on your own. There's not going to be a basis unless there's some common fund theory floated something like that. But other than that, everybody's kind of on their own in the trust proceeding other than the trustee.
And I always think it's a very important time to discuss how fees are paid in that initial meeting with your clients, so that they don't make the erroneous assumption that if they bring in unsuccessful conservatorship petition and we get into a lot of wrangling, that their fees are all paid by mom and dad's estate, because often that's not the case.
Yeah. So one last slide. Whoop. The epilogue here. Court has made some preliminary rulings. Dad dies. And now there's infighting between dad's kids, cremation versus funeral, or division of the assets. And whether any of dad's assets should be used for now supporting mom. Continued control and management issues. Of course, dad's kids are concerned mom will use up part of their inheritance because she's living longer. These are issues we run into with second marriages. And
well, and it's not just dad's kids. Sometimes it's mom's kids as well.
Yeah.
Many of them are just as interested in receiving an inheritance as dad's kids.
So as Terry said, no good deed goes unpunished. People sometimes start these cases with really good intentions, and before you know it, they didn't have lemonades and make lemonade. They just made a total mess. And I think our job as attorneys and officers of the court is to try to prevent these horrible situations from just going south, because too many of them, that just seems to happen. And years later, you can't figure out how to ever bring the case to an end.
Yeah. The runaway train, and everybody's on it.
Yes.
Yeah, and we've all been in fights over, for example, who has the right to make the decisions regarding dad's funeral and burial arrangements. And suppose, mom's the second wife, but she wants to be buried with her husband, and dad had purchased a plot for he and the first wife. So what happens there? Who has the right to decide whether dad gets cremated? No, it's no longer the conservator. They're out of the picture at that point. No longer a court-appointed counsel for dad. He's out of the picture. You go to the health and safety code. Is it spouse? Is it children, or the majority of the children? We've had a situation in which the right to control the disposition, the funeral arrangements and disposition of the remains was built into a settlement agreement to try to avoid a fight that probably was going to arise otherwise. And I've had to go to court a couple of times in battles over who gets the ashes.
Yes. Yep.
Are they allocated between family members? Who gets them? So you want to try to avoid those things as much as possible.
So those type of provisions should go into the power of attorney for healthcare, because that's the one power of attorney that does not expire upon death. There are provisions such as burial that will continue post-mortem. So Larry should have taken care of those things, but obviously in this case, Larry lawyer didn't. Okay. So.
Well, job well done. Samantha, do you want to start the questions and we can go from there?
Happy to do that. So the first question came in, it's in the chat. Shouldn't Larry have prepared powers of attorney to avoid this as part of his estate planning obligations?
Yes.
I think Larry did. The answer is yes, Larry did, but then he did not designate successors. So when dad or mom designated dad and dad no longer has capacity, there's nobody there. So, and then as far as the form of the power of attorney, he just used the easy, simple form, which in some instances, if somebody has reduced capacity, you want to try to keep it simple, because if you give mom a 30-page power of attorney to sign, she's never going to understand it. So you have to keep all that in mind, I think.
I do too.
Yeah.
Mhm.
The next question we have is, what do you do when you know a trust exists because of a title search, but the trust itself cannot be found?
You mean the
Happens all the
underlying trust
time.
document? I'm sorry, I didn't hear it.
What do you do when you know a trust exists because of a title search, but the trust itself cannot be found?
Discovery.
So if no one can find the trust document.
I actually had this scenario up in Sacramento more recently. And so we opened a probate estate and got a special administration to take control of the assets. But we knew one of the decedent's houses was in the trust. We eventually, luckily, close to a year later, found the original documents in the hoarded mess of one of his primary residence. But sometimes it happens, it's not there. And in that case, I've, under the probate, I filed a petition for instructions asking the court to basically, we either file a separate trust action under 17-200 and bring it under court authority, and then you go to the laws of intestate succession, or I can think of one case with Judge Sugiyama. We did a petition for instructions, and he just declared it's all going to end up going through the probate estate anyway, which would be an intestate, and he just combined them.
How do you know the trust hasn't been revoked?
We don't. But if you can't find the documents, that's a problem. But you can go to banks. If you can find there are bank accounts and things like that, the banks many times will have copies.
I can tell you all right now that I'm literally dealing with this exact scenario. And we got a court order suspending the trustee. The title search showed that the trust property was sold. So I have actually subpoenaed the title record or the title company to see if, you know, during the sale, they had a copy of the trust. So I'll keep you all posted whether they do or not, but I will likely be in the same situation if they don't.
My guess is they'll tell you they obtained a certification of trust that someone signed, but they didn't get the actual trust document.
Mm-hmm.
Well, thanks for.
Banks and brokerage houses, though, sometimes are a good source.
Yep,
Yeah.
agreed, agreed.
So the next question we have is, you brought up the notion of bringing a neutral fiduciary into the case. I know this is common in Contra Costa, but do other counties prefer having fiduciaries come in?
I find it to be very case dependent. I mean, I practice in 5 counties pretty much. And, you know, again, the idea is to protect. So if it's a family squabble, I do find that courts are leaning towards private professional fiduciaries to the appointment of one.
Yeah, that's been my experience.
And usually when you go in that circumstance, there's some reason, for example, that a family member should not be serving. You know, maybe they take an excessive compensation. Maybe they refuse to turn over documents. So there's justification for getting an independent third party in there who's a trained professional who can try to get a handle on what's going on in the case.
If you get a temporary fiduciary trustee, don't you still have to get a petition to appoint? And don't you still need a conservatorship of the person to take over dad's healthcare? So the fees and the delays are still there?
Is this using our scenario? Is that?
I'm presuming so. It doesn't say specifically, but I would presume so.
Well, sometimes the judges, when these, you sort of, as these issues get parsed out at the first hearing, or, you know, ex parte, if you can have some FaceTime, you know, with the judge, and they make a decision, sometimes they'll say, just present an order, and I'll sign it. But it doesn't happen all that often. And so, yeah, you can end up having to file petitions all over the place.
I mean, I think as to the underlying question as to whether or not, in order to get a temporary trustee appointed, do you submit essentially an ex parte application for that as well as a general petition, just like you do in a conservatorship proceeding? And I think the answer on both is yes and yes. And if the conservatorship of the person or person in a state is necessary to assure that dad's healthcare needs are met, yes, you have to do that. But what's the alternative? If you don't, how do you stop the bleeding? If it's financial bleeding or if it's neglect or failure to handle his medical needs appropriately, you have to do it to address it. And hopefully if you address it up front and get it under control, you can avoid a bigger disaster.
And in that case, if you're dealing with a private professional fiduciary as a temporary, I would probably, again, reach out to all the attorneys, get their clients to consent, and then your ex parte is, very easy. You've got consents from all the interested parties, and off you go. Make it a lot easier. Could I just go back on one thing with the lost trust? Another thing that often happens is you find a copy of a will, but not the original will. So now you're dealing with filing a probate to prove a lost will, which is not the easiest thing to prove because the presumption is, of course, that the original will was destroyed. I don't know if anybody's dealt with those lately. Yep.
Yes.
They're all fun.
Mhm.
How do you deal with conservatorship actions as proxy battles for trust contest while mom or dad is still alive?
As a young attorney, right after I joined this firm 34 years ago, one of the first cases they gave me was a will contest down in Southern California. But there was a conservatorship action before the person passed away. And so my boss at the time in the conservatorship action flew down, brought a court reporter, and asked the judge at the conservatorship hearing that maybe we can resolve this today, Your Honor. May I have 5 minutes to voir dire the proposed conservatee? He established by transcript that she did not have any capacity, which was a smart thing because he was right in his guess that there'd be an immediate attempt to change her estate plan and cut our client out. And but I haven't seen it ever since.
Next question we have is, what authority does a court in a conservatorship action have to order mediation as opposed to in trust under Breslin?
Like in my experience, the court typically hasn't ordered the parties to mediation. The court has encouraged it. They have asked all parties if they'll agree to go to mediation, and then based upon that, they'll issue an order because basically counsel have stipulated to it. But just a flat out order to go to mediation, I found the judges reluctant to do that. I mean, in Breslin, which is the very recent case, parties were afforded the opportunity to go to mediation. And I haven't fully read the case at this point, and I don't know whether it was conservatorship or trust or a combination thereof. But if you have the opportunity to participate and don't, you can be bound by the outcome. And so somebody, I'm sure, had filed a petition to asking the court to approve the settlement agreement, gave appropriate notice. The parties may have at that point came in and objected, but they hadn't participated in the mediation. So they'd basically given up their right to carve out the terms. I mean, that would be my guess without fully reading the case. I just saw the
Right.
little paragraph description of it. And
The court,
for another day.
court can't order you to mediation if you're going to pay for it. They can't force someone to spend money. But I have seen judges, both probate and civil departments, order parties to 2 hours free mediation under the court panel system.
Mhm.
And say, you can walk out after 2 hours if you want, but the judges know darn well if there's some momentum, people will stick around.
In an
Not
application,
always.
if you're lucky. In an application for a 730 exam, how does the court decide who the neurologist will be? Does the applicant propose one?
Typically, in my experience, they do. Or I've had occasions where a couple of names have been proposed, and the court will then direct parties to either reach an agreement or provide the names. I'll put them in a hat and I'll pick one out. I think Judge Sugiyama used to do that occasionally.
Yeah, that's been my experience.
Yes.
How do you handle a situation where there's only one account in IRA that creates a need for a conservatorship? All other assets are properly handled by the trust.
You mean the IRA does not have a beneficiary designation on it?
I believe it's just outside of the trust. It's not a trust asset, so it creates the need for a conservatorship of the estate.
So normally, things like retirement accounts or life insurance are outside of a trust, particularly with life insurance for tax reasons, likewise for retirement accounts. However, they generally will have, when you set them up, beneficiary designations. So they don't create a separate need for a conservatorship.
Except if you need to get money out and you don't have appropriate language in a power of attorney, they won't necessarily, even if it's for a spouse who's asking, they won't.
Oh, you're saying like for a withdrawal?
Withdrawal, you need, in addition to the RMDs, or the RMDs are not set up for automatic distribution every year.
Yeah, I think that was the purpose of the question. RMDs, $10,000 a year. I think you would probably still have to get a conservatorship, but go the route of which, you'd waive any future accountings. You'd basically be a placeholder,
Or if the individual had set it up where the RMDs went into an account that they held as trustees in their trust.
Of course.
Which is an individual account, they wouldn't necessarily need it.
I recommend that to my clients. I said, when I recommend they go back and they check their beneficiary designations when we're doing an estate plan, said, while you're at it, if they're retirement age, I said, take a look and make sure that the RMDs will come out automatically every year if you don't request otherwise. And then that can go into a trust account or some joint account that they hold.
But otherwise, I think you're stuck with, if you need extra money out of that IRA, you're stuck with trying to get an order from the court. But that does not mean that the financial institution, which is under federal law, banking laws, are going to embrace that order.
Well, you also, for example, if all of a sudden you want to go in and withdraw funds from mom or dad's IRA, does that potentially skew the overall estate plan? Because maybe the parents have set it up, or the person has set it up with one child to get this IRA, which has X number of dollars projected, and then other children or child will get other assets. So all of a sudden, if all the money is being drawn out of the IRA and not being spent on the other side, or vice versa, that can skew the estate plan. And I've seen litigation over that. Or proportional withdrawals if there are multiple IRAs.
Right.
The next question we have is, what happens when an attorney represents an elder in a conservatorship proceeding is declared to have incapacity, but before conservator is appointed? Does that attorney have to withdraw? Get a gal for the incapacitated client? Seems like a precarious position to be in. Let me read that one more time. What happens when an attorney represents an elder in a conservatorship proceeding is declared to have incapacity, but before a conservator is appointed? Does that attorney have to withdraw? Get a gal for the incapacitated client? Seems like a precarious position to be in.
Okay, so I think this is kind of like Larry the lawyer, right? Who, oh, I know mom, she's good. I don't think she needs a conservatorship. And then, the son or daughter goes with another attorney, they file the proceedings, whatever. Mom is deemed to have incapacity. At that point, I think this is the question. What does that lawyer do?
I had a case last year where a woman came to see me a couple of times. I thought she had capacity. She just was having some wild mood swings and had hit her husband. So he moved out of the house, moved to Southern California, and then filed a proceeding to conserve her. And I had sent her an engagement agreement. She went in to court one thing they did was they got court-appointed counsel before the first hearing. So in following up with her, she said, well, I got a call from this attorney and I'll go to the first hearing and see how that goes. Of course, at that hearing, the court signed an order for temporary conservatorship. She shows up the next day in my office with a large check and wants to hire me and the signed engagement agreement. And I couldn't do anything. As soon as she told me she was conserved,
Mhm.
so that was a problem. And so she did have court-appointed counsel, but she said, well, I want you. I said, well, I bowed out.
Mhm.
Well, and the question asks about, the status after determination of incapacity. I think based on our discussion here today, we're assuming that it's in the context of a conservatorship proceeding. But what if one of the kids has gone out and gotten a doctor or doctors to provide letters basically stating that mom no longer has capacity to handle her affairs? Isn't the position of the attorney a little different at that point? Because I think we've all seen letters that are woefully lacking, particularly in any detail, and sometimes they come from individuals that are writing a statement of opinion that's outside the scope of their practice, and then the kids will try to use that to trigger a right on their part to step in as successor trustee and take mom out of the loop. So, where's the determination of incapacity coming from?
Our next question is, what level of capacity is required to execute an advanced healthcare directive, even if this client doesn't have contractual and testamentary capacity?
That's pretty tough. The bar is pretty low for execution of a will. And if someone's going to be signing an advanced healthcare directive, particularly a relatively simple one, it'll probably fall within the range of what's necessary to execute a will. And you've said the questioner says that the individual doesn't have testamentary capacity. Well, if they don't have testamentary capacity, which means they wouldn't have the capacity to execute a will, I question whether they would be able to sign an advanced healthcare directive. And then this question also, who are they going to appoint? Is it going to be their new friend or neighbor, or is it going to be the child who's been at their side all their lives?
Those cases, I have actually sent them back to their primary care physician with a simple document. And I said, you have to work this out with your doctor and put a place for the doctor to sign, attesting that they had capacity. But it was the one I can think of offhand. I wasn't worried about the person who was receiving the authority to act.
Next question we have is, any suggestions on how to proceed in a dissolution of marriage proceeding when the opposing party, wife, appears to possibly lack capacity or at least have diminished capacity due to mental illness? Do you not want to have a default judgment granted and potentially later set aside?
Whenever I have a client going through a divorce, the very first thing I do is call the opposing counsel, the family law attorney in that matter. Number one thing to do, particularly if your practice is all estate planning, conservatorship, you can just get yourself blindsided without even knowing it. So I always call the family law attorney and then direct my client to, if my client is the one that might be struggling, I will get a family law attorney for that person as well.
And you probably may want to consider requesting appointment of a guardian ad litem.
Yeah.
So
Very
kind of the follow-up to that is, if the wife is not represented, is your advice the same?
So I would not be representing the wife. I can't tell the wife, what to do. No.
I think
Or if wife doesn't have an attorney to call? If you represent husband, wife doesn't have an attorney.
Who do we represent? The husband?
Husband?
The husband. So wife is in the divorce proceedings in pro per, so there's no attorney to call on the other side to talk to.
Oh,
I'd call a family law attorney. I'm not, aware of enough of divorce proceedings and family law.
Well, the
Yeah, I
the
mean,
one thing the one thing you could do as the husband is file a conservatorship for your soon-to-be, divorced wife or spouse. I mean, the problem there, I think, is, and correct me if I'm wrong, because you guys are infinitely smarter than I am, but if an individual lacks capacity during a dissolution, then the dissolution can't continue. Is that, I was under the impression that an individual needed capacity the entire time in order for a dissolution to occur.
And that's why I would recommend estate planners to call a
Yeah.
family law attorney
Get family law counsel on board
right
quickly.
away.
The
And
family law counsel rarely understand conservatorships.
well, just to plug, we do have a family law attorney coming in a couple of weeks, and perhaps that question we can ask of her.
Hold that question.
As counsel for petitioner in which proposed conservatee has dementia and is a puppet of the financial abuser partner, must we share the confidential statement with court-appointed counsel?
I think court-appointed counsel would be entitled to. Are you talking about the confidential supplemental information?
Sounds like it's a must we share the confidential statement with court-appointed counsel?
I think court-appointed counsel is entitled to see that.
Yeah, this is court-appointed counsel for the proposed conservatee, who you said is under the influence of the abuser.
So it's as counsel for petitioner in which proposed conservatee has dementia and is a puppet of the financial abuser / partner, must we share the confidential statement with court-appointed counsel?
Yes. Court-appointed counsel is entitled to all pleadings.
Now, I believe also the probate code specifically provides that any party can request the confidential supplemental information, and that must be provided. Not the confidential conservator screening form. That is strictly confidential, except for the probate, the court investigator, the court-appointed attorney, and of course the judge. But yeah, it happened to me. I think it's, I can look it up real quick, but yeah, the probate code is clear. So for all of you that didn't know that, you can actually request the confidential supplemental information, and it must be provided.
Well, court-appointed counsel for the proposed conservatee should have all of that.
Yeah, but I'm saying if there's court-appointed, and let's say, Terence, you represent one side of the kids and I represent the other, and you filed the underlying petition, I can request from you the confidential supplemental, and you're required to provide it to me, even though it's confidential.
Sure.
The next question we have is there any recourse against a bank that ignores a request to honor a DPA for financial management, leading to the necessity of a conservatorship of the estate? And in the interim, there is significant bleeding of assets due to continued financial abuse of an abuser close to the incapacitated elder.
Get a hold of the bank's legal counsel. Yes, there is recourse. It's not going to be very quick because they're probably going to fight you on it. And banks will routinely say, how do we know that the power of attorney hasn't been revoked?
If you end up filing for conservatorship, I've had this, then we want to include in the orders that all powers of attorney are suspended and revoked. And that has worked with Wells Fargo.
I hate banks, so I don't have an answer.
I don't have the best experience with banks either.
Yeah, I follow Terry's initial comment, and usually what I do is make sure I have a certified order, again, that says any prior powers of attorney are revoked, and I try to get to the legal department of the bank as quickly as possible. I mean,
But I think the question went to the bank's refusal to honor the power of attorney, which leads to the necessity of filing a conservatorship proceeding and financial bleed in the meantime. So I think it was more, is there recourse against the bank for refusing to honor? And there is the provision, is it 4500 section of the probate code dealing with refusal to honor power of attorney. So yes, there is recourse there.
but sometimes it's a good idea, if that happens, ask the bank why. You know, what is it? Is it because that power of attorney is 22 years old? Or, you know, is it because something's missing? I mean, you know, find out. You can't overcome an objection if you don't know what the objection is.
I have that same problem with the bank right now, where apparently there's two competing powers of attorney and the bank is refusing to honor either of them. So
Yeah.
off to the races.
I have a similar one that the banks just said, nope. I went and got a court order saying you have to honor it.
Yeah.
Said, don't care. That's why I hate banks.
All right, well,
Yeah,
Go
I
ahead.
have a question, but I've noticed that Ann Wolf, the boss, is telling us that we should wrap this up. So I for one
I resemble that remark.
resemble. So yeah, Ann, do you want to do closing remarks,
If there are
or
more questions, what time is it? I mean, you guys can go a little longer if you want. I just
I have a dying question, only for my own edification. So
we don't want you to lose sleep tonight. So
oh no, never. Okay, so here's my question, and I deal with this constantly, so I'm really kind of curious. I struggle with this idea when I'm court appointed of advocating zealously for my client versus this, what is objectively in the best interest of my client. So I struggle with this subjective versus objective kind of approach. And many times you just get that order appointing you for all general issues. There's no kind of guidance one way or the other. And so I deal with these, or when I'm required to do a report of counsel, right? I object because it's my duty to, but then I put in something there like, in the grand scheme of things, my client objects, but here are my concerns or whatever, my observations, which is kind of like a hint, nudge, nudge to the court, so to speak. But I've been reading in the trust, like quarterly stuff about like this kind of growing movement of, you must advocate for your client, period, end of story. Don't do anything else. So my question is, how do you kind of work that out, so to speak, or can you at all? And then conversely, if you're appointed as guardian ad litem, aren't you just acting as that individual and not necessarily as an advocate for that individual?
So just, working backwards,
Yeah.
when I'm appointed as a guardian ad litem, I'm a protector of usually trust assets, or, so that's the concern. It's very different from the role of court appointed counsel. And I struggle with the exact same issue as court appointed counsel. I agree with zealous advocacy. However, I have had cases where the reason the proposed conservatee was objecting to the conservatorship was because he or she thought they were going to get ripped out of their house, which probably would be a good idea for the client. And I tried to write into my report to the court that observation, let the court know my client is vehement. They really object. They don't want to leave their home, and and that's, I think, the best you can do. I don't know. Correct, Gary? Yeah.
I've submitted a report about 2 weeks ago that did just what you suggested, Doug, and that is I had a section about concerns for the court to address. And I didn't offer a position on them, but these were just my personal observations that I thought were central to protecting my client's interests, but I did it by posing a question because I didn't know. This is a hard one. I mean, and because we have 40 some odd people on the panel, and we're getting a lot of appointments lately, and it's, where does our role start and end? And
Right.
that's hard. We're not a guardian ad litem. We don't get to make the decisions.
Right.
We are an attorney, and that's hard.
Sometimes the conservatee will help you out though, because they will, if they can articulate the reasons, they will tell you why they're opposed to it. It's because they told me I'm going to have to go to a nursing home. They're going to take my car away. I can't play golf anymore. Whatever it might be. So you can, proposed conservatee objects. And he has some real serious concerns, A, B, C, D, and then maybe you can address those and come up with a less restrictive alternative, or, at least the court will know what you're dealing with without violating the confidence of your client, and without still advocating for him. You're objecting and you're telling the court why you're objecting.
So then on that same kind of thought process, when you're appointed as a guardian ad litem, right? So you are essentially the person protecting the asset, or, and beneficiaries are fighting, mom or dad is clearly incapacitated. They're fighting back and forth, racking up attorney's fees. Okay. What do you do in that situation? I mean, you say, hey, court, I don't want my money to be spent, but at the same time, what are you allowed to advocate? Do you hire your own attorney to represent you as guardian ad litem? To, what is your respective positions?
I mean, typically they don't want you to. That's why they appoint you as counsel, and then that way you don't have to have an attorney. But GAL, it's what's in the best interest of the beneficiary in the trust proceeding.
I have pointed out in cases, and it's, directly related, the more money in the case, the more fighting that's going on and the fees are going up. And I've objected to ongoing wrangling. I have.
Have you come into the position where the fighting parties are going to call you as a witness now because you're guardian ad litem?
I've never had that happen. Yeah.
But I raised that in the hearing this morning on a case.
Mhm.
Very concerned about the infighting between different factions within the family that are using up the remainder of my client's assets.
Yeah.
All right, thank you.
You're welcome.
Anything else we can teach you, Mr. Houseman?
Oh, there's plenty, but we don't have enough time. That's for sure.
No, we're not picking on you, Samantha.
I'm good with that.
For a reason, yeah.
There's one more question. Looks like in the Q&A.
It says, guardian ad litem for a minor is required to have an attorney in probate, to my recollection.
In a guardianship case?
No, it says guardian ad litem for a minor is required to have an attorney in probate, to my recollection.
Yes, if they're not an attorney themselves. If they're a private individual, yes, they have to be represented by counsel.
All right. I think that's it. We went over a little time, but it was because of your wealth of knowledge, all three of you. I did personally really like the interactive hypothetical because, as you guys said from the get-go, it reminds me of just about every possible case I have in some form or fashion. So for better or worse, it was needed to discuss. I think I can speak for a lot of the participants that there's the sections of hypotheticals that apply in their day-to-day practice, and the what to do's in those various situations. So I, for one, want to thank all three of you for your time. Terence, particularly, I think you are on vacation, so I do appreciate you carving out the time as well. Kathryn, Craig, you guys are great as always. And I think these panelists are more than happy if people have questions, to pick their brains. These individuals have practiced a long time. And with that comes seeing just about every possible scenario and having dealt with it. So thank you for your time, for your knowledge, and for continuing to be a shining example of what all of us young professionals in Contra Costa County should try to be like.